Welcome to the Family Law Now podcast. I'm Russell Alexander. Today's topic is Ontario courts to paperless. Could COVID-19 drive digital change? We've seen a lot of restrictions on access to the Ontario court system because of the pandemic. Courts are closed. They're only hearing emergency and very limited matters as a result of the infrastructure that we're going to talk about. We've got some special guests with us today that are joining us who are going to help us understand what changes can be made. We have two lawyers who are practicing in paperless environments right now. So Rich Harris, start us off, introduce yourself and welcome.
You bet, Russ. Thank you very much, and thanks for putting this on. Like you said, I'm Rich Harris. I'm the principal of the Harris Law Firm. We're a family law only firm located in Denver, Colorado, primarily, although I'm coming to you today from my bedroom with my favorite dog, but it's nice to be here.
Thanks for joining us, Rich. And we also have Brian Walters. Welcome, Brian.
Thank you. I'm Brian Walters. I have a firm in Texas, Walters Gilbreth, that we have about 20 staff in Houston, Austin, and Dallas. I'm actually coming to you from California, but I'm happy to be here and share what I know.
Thanks for joining us, Brian. And Lynn Kirwin, welcome.
Thank you, Russ. So my name's Lynn Kirwin. I practice in Barrie, Ontario, Canada. I am a lawyer at Galbraith Family Law. We do just family law only. Our courts are completely paper courts. It is not a paperless court. We have to file papers in just about every type of proceeding. We have about 12 lawyers on our staff, and the complete staff is about 20 people.
Great. Well, thanks for joining us, Lynn. Really appreciate it. So I think some of the changes we're calling for will become the new normal for many Ontario courts after the pandemic is over. The caveat to this, I know judges are working very hard. They're very concerned about access to justice for the public. They want to show leadership role, and they are somewhat bootstrapped by their technology right now. We have clients complaining that they can't access courts for parenting disputes. They don't understand that how the system can grind to a halt so quickly when people need help. Obviously, in Ontario, safety is the number one issue. We want to protect our staff. We want the court staff to be safe. We want judges to be safe. So there are a lot of restrictions that have been put in place. We're calling to support a new modernized system of electronic filing and tracking, and hopefully go to a fully paperless procedure that we see throughout courts in the US and other jurisdictions. Do you want to talk a little bit more, Lynn, about what we experience in Ontario in terms of our system and how it's paper-based?
Yeah, I mean, every single thing that you do in our court basically is paper. So if you start an application in our court, the application and the answer, the reply, the motion material, it's all contained in a continuing record. And in that continuing record, it's like a book, and it can be extremely thick. And we just keep adding more and more volumes to that continuing record, which is the book that the judge gets and relies upon whenever we go before the judge. So you can imagine how cumbersome that can be for a judge who, sometimes the paper gets misplaced. Sometimes people don't update the table of contents, and we're all sitting there going, okay, wasting a lot of time in court looking for things. So yeah, it's all paper-based. It's unfortunate. We've never progressed beyond that. But we are restricted by the Ontario Family Law rules. And in our Ontario Family Law rules, until we amend those rules, we're stuck with what we got. And so there is no e-filing and there's no e-service. It's all has to be done by paper.
Right. And it's come to a screeching halt. The Superior Court last week or a few weeks ago suspended all proceedings. Only emergency hearings can occur digitally, and there's a variety of opinions as to what an emergency means. Some judges are taking a strict interpretation of the practice direction. Other judges are a little bit more fluid and practical, trying to come up with solutions for families. So that makes it difficult for lawyers to advise their clients, in terms of what's an emergency, what's going to happen if we go to court. And just so our listeners understand, it is so bogged down that I am informed, and this may change in the near future, that when we send an emergency matter to the judge, it's done via email, electronically. The judge doesn't even have access to the court file. So all they have is the information the lawyers provide. So judges are asking lawyers to provide copies of any relevant orders. They're asking lawyers to provide draft orders that they're seeking. They really have nothing, and they're working in a complete vacuum. And a lot of that is because the paper files aren't in storage, the staff need to bring it up. They're not in, and there's just no mechanism in place to allow the digital hearing to go forward. So, we're at a standstill, and I think what's in place now is going to be changed. We did receive a directive from our Chief Justice of the Superior Court on March 27th, indicating that they're going to be making changes and expanding services on April 6th. Sorry, it's March 27th, April 6th, they want to expand services. That could include case conference, that could include motions. We're not sure what it's going to include yet. And it sounds like it may be inconsistent across the province based on the facilities at each courthouse. You want to talk a little bit, Lynn, about what's in place now?
Yeah, I'd love to talk about that, Russ. The directive seems to me to be extremely limited. Again, I think our Chief Justice is confined by the family law rules, and the family law rules already have provision in it for teleconferences and video conferences. That there are already rules in place for that. It's just that we've never really made use of them until now, and we're saying urgent, and it's very limited. It's urgent motions where the child is at risk, and urgent case conferences. And they're conducting these by way of a teleconference. And the lines, there are not enough telephone lines to even be able to handle that. So there's no video conferencing set up, even though the family law rules have stated that you can have a video conference for a motion or a case conference. It's just never been used. And it's beyond me why. Other than the technology, it costs money for the technology.
Right. And, there are some limited video bail hearings that I've seen where they don't want to bring the prisoners in. So maybe we should go to the jails to practice family law. I'm not sure, but that's, how far behind the system is. But that's in stark contrast to what we're seeing in some jurisdictions in the US, where paperless filings are not only the norm, they're mandatory. So let's talk about some experience we have from our panel today. Rich, you're in Colorado, and I know this is, you're probably shaking your head thinking you haven't dealt with paper the way we have for 20 years plus, and wondering what the hell these Canadians are doing. What's going on in Colorado? What do you have in place? How long has it been there? And how do you find it?
Well, first of all, you're right, I'm shocked. You Canadians are usually way ahead of us and more advanced in lots of ways.
Well, you're catching up on the socialism part real quick, I think.
Yeah, it seems like it, doesn't it?
Yeah.
First of all, I'm sorry to you two practitioners and to all of the presumably thousands of people out there that are in limbo. My gosh, our clients are freaking out. The general public here is freaking out because our courts are physically closed. But, out of all the things we're worried about and answering questions about, whether or not we can file things doesn't cross our radar, or hasn't. We've been in an e-filing environment for like you said, Russ, a couple decades. Our law firm of 50 plus employees has been paperless for more than that. The courts are limited, but we lawyers are just used to filing things electronically. We avoid paper wherever possible.
Right. And similar in Texas, the courts, they've had mandatory filing since I think 2014. That was spearheaded by the Supreme Court of Texas. Brian, can you touch base and maybe let us know your experience in Texas with respect to e-filing?
Sort of similar. We're used to it now. It's become second nature. And we actually had sort of a dry run with this in Houston, which is where I'm based out of. And we do things by county here. So I'm in Harris County, which is 4.5 million people, third largest county in the United States. And so we had 2.5 years ago, our county essentially shut down when Hurricane Harvey hit, if you recall all that flooding. And our office building was closed. The courts were closed. There's two big 20-story court buildings. One of them is for criminal, one's for civil. The criminal building is still partially closed. We had the civil court reopen pretty, within I think about 2 weeks or so. So we had a bit of a dry run, and that, everybody knew that was going to end relatively soon. And so this is a little bit more of a problem because it's uncertain. That said, we've still been able to we've been able to have hearings by video. We've been able to get orders signed by electronically filing them. So it's moved along, but it is, ultimately no substitute for actually open and functioning courts. But it has made things easier. And the e-process thing is just something we take for granted. The e-filing and paperless, it's just what we have, and we're used to it.
Yeah, interesting. We both, Rich and Brian and I know a lawyer. We love Ken Peck, who's in South Carolina, but he gave me an interesting quote when I was preparing the paper that we posted online, proposing the changes. Ken said he's filed in Denver court once from a tent in Grand Teton National Park, another time from a plane 35,000 feet up, and another time from the backseat of a car traveling through New Hampshire. It's life-changing. So has that sort of been your experience, Brian and Rich?
Yeah, I agree. It's great, and it's just so much easier, and it's like sending an email. It's really simple.
Right.
Yeah, it's pretty terrific. Although I will tell you that there are some challenges with it. You can file up until midnight on the day of a deadline. So if you're trying to, for example, make sure your associate's getting something in on time, you can't yell at them until 12:01 a.m. when I'm usually hopefully fast asleep.
Yeah, that's an interesting point, though. What advice do you have for lawyers and the public in Ontario in terms of some of the downsides of going fully electronic? We've all heard of stories of lawyers who are reluctant to go paperless, and they hold on to the file as strong as they can. They're not going to let that paper file go. What are some of the downsides of doing it digitally?
I'll go first. So, the management piece is one. Another is that, for better or worse, in Colorado, we have a single vendor that runs it. And I suppose that's efficient from the perspective of a state of 9 or 10 million people. But that vendor sets the prices. They've got a monopoly. There have been a couple times, especially early on, they had glitches. It's not like you can go anywhere else. Then we're in a situation where everything's dead. It's mostly good, though,
Right.
and positive.
That's a really interesting idea, and I'm not sure how well that's going to sell in Ontario. But when you're saying a vendor, you're using a private third entity to get the documents from your office to the judge's desk or computer screen.
That's right. That's right.
And who's the vendor that you're using?
It's a statewide contract, and forgive me, I don't know what they're called these days, but it's one of the big guys. It's LexisNexis or
Right.
one of the big companies.
And what are the fees associated with that? Do you have a licensing fee or filing fees? How's that work?
For us, it's a per document filing fee. I don't know off the top of my head how much it is. It's fairly nominal. It adds up, of course, but nothing compared to what we used to spend for postage and paper and courier.
And in Ontario, we have to pay a filing fee to the government to process a divorce. Do you have to pay a filing fee to the state as well to process your documents?
Yes, those are all the same, and those have been raised over the years. The e-filing fee is a separate fee, an additional fee.
So does the fee that you pay for your state or local government, is that collected by the third party private company as well?
You know, Russ, that's a really good question. I'm not sure.
Okay.
Our expert staff handles that.
Let's flip it over to Brian. Brian, how does the mechanics of filing work in Texas?
Yeah, there's multiple private vendors that are competing with each other and you can choose whoever you want to handle the e-filing. And there's a central database of emails that the state bar has available that's open, so that you know that you're e-serving the right person. The fees are nominal, and as Rich said, much less expensive than it used to be when you had to run people down to the courthouse, and less expensive for the clients because a lot of those fees would get passed on to them. So it's a nominal, very small, probably around $1 per filing. And there's lots of competition. So we haven't had any problems with it.
And do they receive the government fees too for whatever's required?
You pay that through them, and then that's passed directly on to
Right.
the government entity.
Right. I've met some lawyers in Ontario who don't have very busy practices or no support staff. So they've told me stories of having to prepare an application and line up at the courthouse for an hour and a half to try to get it filed. And you think, what an incredibly inefficient use of legal resources, just standing there waiting. But so we've got some proposals. It's easy for us to be armchair quarterbacks and criticize all the time, but what we've tried to do is come up with some ideas that Ontario can implement to improve and maybe go paperless or more digital. One is switching the default vantage point to create a new normal. So rather than having the electronic version be the exception, I would suggest that should be the normal and paper should be the last resort. Again, electronic filing should be the default. Hard copies, I think, going forward should be rare. In rare, I mean maybe trial exhibits of original documents that require verification or inspection or things of this nature. Rich, do you have another point to contribute?
Sure, I would just add with respect to the exhibits and the other documents. We can file all sorts of lengthy exhibits periodically. Our paralegals need to think about breaking those up because if they're large files, they have a hard time getting over. But our rules accommodate for electronic signatures, of course. I would add too that just a few days ago, Colorado Supreme Court amended our rules to allow notarizations to occur remotely. So that sort of takes the last vestige of why we had to meet in person and stamp things with real signatures. At least for now, notary requirement is now virtual, which is great.
Right. And in terms of the steps, are you using DocuSign or what programs are you using to get these signatures done remotely or digitally?
Yep, we're using DocuSign and also the fancier version of Adobe.
Right. Adobe offers the same program. All right. And Brian, you've got some tips too.
Right. I mean, I think I've echoed everything Rich has said so far. There's nothing I've really I really think otherwise than that. I mean, it's I think either one of what the systems that we're using here seem to work well. You might want to make it some minor changes, but I don't have anything specific to add to it.
Have you guys evolved to digital courtrooms where you're conducting motions or conferences or even some trials remotely?
We have at this point both sides have to agree to do that, and that means whoever's the foot dragger usually won't. But we have had a couple of those type of hearings which have worked just fine. Usually over pretty simple procedural matters.
Right. So the foot dragger doesn't want to have a hearing that quickly, I imagine.
Right, and they just object to it for just to foot drag.
Just to be objectionable. All right.
Exactly.
Rich, how about you? Any virtual or digital conferences, motions?
Well, we've long had telephonic hearings in our cases,
Right.
especially for simpler procedural hearings. But since the virus has hit, we're handling all sorts of full-blown hearings on the merits by phone. There are some jurisdictions, and our practice, like Brian's, is county-based. So there are certain jurisdictions where they're implementing within the last week video hearings. It's not very common here, other than for criminal situations like you guys apparently have in Canada. But I suspect there's going to be a lot more of it. There needs to be, because from my perspective, there are due process issues under our Constitution with not being able to see witnesses, at least on video, in my opinion. Nobody's objecting to it now, but I think it's going to come up.
Right. Interesting point. Lynn, can you jump in here?
Yes. So in the commercial law context in Ontario, there have been e-hearings and paperless hearings, and that occurred in 2014. So it's been around in a commercial context where the judges, even without the consent of the parties, will order an e-hearing, electronic hearing. So in two cases that I know of, the hearing went relatively smoothly. The Justice New in the Chandra versus CBC case commented that the witnesses was hearing the witness through a video conference was as spontaneous as if the witness was right there, physical in the courtroom. So the sound system was excellent. They had a split screen with the document shown on the screen and then shown to the witness, and questions, cross-examinations, just as if the witness was right there. So it has been happening. It's just the judiciary and lawyers are not embracing it. They have a fear of it. And so, even though it's possible to do this and a judge can order it in a commercial context, people are still reluctant to go ahead that way.
Yeah, I think it was Justices Brown and Mew that you wrote about, and they seem to be ahead of their time.
Yes. Justice Mew totally embraces it. And, in one of his judgments, Bank of Montreal versus Fabish, he said, you guys are like dinosaurs. Let's move forward with the technology that's there. And he's chastised lawyers and judges for not moving forward with the type of technology that is available.
That was several years ago too, right?
Yeah, 2014, Justice Brown.
Right.
Yeah.
I've personally done hearings where witnesses were out of province or weren't able to travel for certain reasons. So we've Skyped them in this. And it was interesting, we would schedule around the witness's time. So we would know, at 11 o'clock, we're going to break the regular testimony to bring this witness in and conduct cross-examination. And the judge in that case had questions too. And I think it's just a matter of making it part of the new normal. Make it, I know there's a lot of lawyers who don't like the idea. And I guess there's an argument that could be made if there's a credibility assessment. The courtroom's designed, sometimes people would argue in part to put stress on litigants because they want, test test the veracity of their evidence. And that's something, maybe you can only do in person. I don't know. Maybe you could do it electronically. What do you think of that idea, Brian?
I think that makes a lot of sense. We definitely bias down here toward live court testimony, but I agree with you. I mean, you can, on the other hand, you can take a video deposition and play that. It's just as good evidence. I don't know why that would be any different than otherwise. And we have a lot of cases down here, as I'm sure you guys do, that involve people that are in other states, other countries. I got an inquiry this morning from an issue that's over in Germany. Also, we live in like you all do, very large urban areas where it's an hour and a half drive to get to the courthouse each way. And, just for someone to drop in and give, some short testimony seems like a waste of time, or for a busy professional, for a healthcare professional to come in and testify about some medical records. It seems really wasteful. So I don't know why we don't do more of that. And maybe this is going to be encourage people to.
Right. Rich, credibility and in-person testimony?
Yeah, I totally agree. Well, I can see the argument that being in a physical courtroom is more intimidating and maybe tests the veracity of evidence. To me, it's so outweighed by the benefits of cost and efficiency of doing things electronically. It's just, I think our colleagues 10 years from now will look back on these kinds of conversations and wonder why we even had them, because we're almost definitely going this way.
Yeah. Lynn, what do you think of the issue of credibility and in-person testimony?
I agree that the benefit far outweighs the negatives of this, particularly in mobility cases in family law, where you've got people that have to travel by plane or otherwise to the jurisdiction where the child ordinarily resides, and they can't afford it. I mean, my clients can't afford it. It's ridiculous that they can't provide their testimony in our jurisdiction in Barrie, just in my office, and they can sit there and be cross-examined. I mean, there's so many women out there and men that cannot afford the type of legal fees that are astronomical because of the archaic system that we are in. If we could have the video conferencing, that would make so much more sense, and much more affordable if we implemented that. So yeah, I agree that it far outweighs the downside of credibility, spontaneous. But as Justice Mew said, he found it completely seamless.
Right. And may alleviate a lot of the jurisdictional arguments. We're changing our Divorce Act to deal with mobility differently. But a lot of it is, the convenience of, the connection to community. Where are the witnesses? Where are the parties residing? A lot of those arguments that root a case in a certain jurisdiction may get watered down a little bit now if we can do it electronically.
Mm-hmm.
Right. So these are great tips, everybody. Thank you so much for joining us today. If you look at our paper on familyllb.com, you can find more specific recommendations that have been made. So let's bring this train into the station, so to speak, and get some closing comments. I want to thank everybody in advance for being here today. I know everybody's incredibly busy, and I really appreciate you guys taking the time out to help us educate the public and our listeners in terms of some changes that we can make moving forward. So again, starting with senior counsel, maybe I'll turn the talking stick over to Rich for his closing comments.
Well, thank you, Russ. I appreciate you doing this. I think it's a great thing that lawyers such as you and Lynn and my friend Brian up there in Barrie are pushing in your great country, or at least your province. I think it's important. I think that, as we look at what's going on with the coronavirus, hopefully modernizing the legal system is one of the silver linings that come out of this. Yeah. I hope everybody stays safe and healthy.
It'd be nice if a lot of these changes, even not just the court system, but even the changes we're seeing in our practice, where we're meeting and talking with colleagues via Zoom and getting that face-to-face connection. It creates a different sense of team and connectedness. And it would be nice to see that continue on as well after all the pandemic is over and behind us. Brian Walters, closing comments?
Sorry, just come and join us in the modern times. It'll be a quick and easy transition, and you'll wonder why you weren't doing it earlier. Just like same with us.
What's that song? All my exes live in Texas.
Something like that. I think that is a song. Yep.
Yeah, well, probably because the rules are slightly different down there too, I think. Lynn, closing comments?
Yes, I just hope we don't lose the momentum. This COVID-19 has been the impetus for judges to all of a sudden say, okay, we got to do something and we got to do it now. We can't wait for another 10 years for the reforms to go forward. We should capitalize on this now. We have an urgent situation. We have judges, our Ontario Superior Court judges saying, we can make use of the technology. We can do it. We just have to continue with that even after the pandemic and carry it forward and not lose that momentum.
Yeah, and it seems the institution of the justice system is inherently slow to change. Sometimes it could take years or decades for the culture of change to implement. But you're right, Lynn. I think this is a good opportunity for all the stakeholders to move the ball forward and look towards a paperless, more digital justice system. Looking forward to Chief Justice Morowitz's direction and information on April 6th. He has a fireside chat coming up on Monday where he's doing some Q&A with the Advocate Society. But it'll be interesting and hopeful that some of the changes they're going to be making and some of the expanded services will include move towards paperless and a digital format. I think it's a must. There's no other options right now in dealing with paper. So those are my concluding comments. I want to thank again everybody for joining us today. I want to thank our listeners and viewers for tuning in to Family Law Now. Be safe, everyone. Thanks again, everybody. Have a good afternoon. And I want to close out with that.
Thank you, Russ.
Thank you, Rob.
Russ.
Take care, guys.